Good afternoon, everyone. My name is Kelly Head. I am a staff attorney at ASISTA Immigration Assistance. Thank you for joining us this afternoon or this morning, depending on your time zone, for our OVW webinar, Hot Topics in U Visa and VAWA Cases. I'm joined by my colleagues, Amy Chung, Senior Legal Counsel at ASISTA, and Leah Ocasio, Staff Attorney at ASISTA. We are very grateful to the Office of Violence Against Women for their support of our TA work, as well as their support for our presentation today. And just some housekeeping matters, there is a chat box and a Q&A function that participants can use for questions today throughout the webinar. If anyone is seeking CLE credit, we have been approved for 2 hours of CLE credit from the State Bar of Texas for today's webinar. If you are barred in Texas, you should have put your State Bar number in the registration form, but if you did not, you can email us after the webinar and we will get you added to the list. If you are barred elsewhere and you're seeking CLE credit, you can email us after the webinar to request a certificate of attendance to submit on your own behalf. So we're going to get started. Next slide, please. By participating in today's webinar, you will be better able to first understand how ICE's new victim-centered directive and the new DHS enforcement priorities impact victims of domestic violence, dating violence, sexual assault, and stalking, how to navigate removal proceedings for your U Visa and VAWA clients, how to apply USCIS policy updates to your U Visa practice, and finally, how to navigate COVID-19 considerations in representing U Visa and VAWA clients. Next slide, please. So our first topic for today will be prosecutorial discretion in removal proceedings. Next slide. We're going to start with a poll. Since January of 2021, has ICE agreed to continue removal proceedings or stated that they were not opposed in your U Visa cases? The options are yes, no, or not applicable. Okay, and we'll go ahead and close the poll. Okay, so I see for most of you, this has not been a situation that you've been in, but I'm glad to see that for some of you that ICE has agreed to continue removal proceedings in your U Visa cases. Next slide, please. We're going to do a second poll now. This is a flip side of the first poll. Since January 2021, has ICE opposed a motion to continue removal proceedings in your U Visa cases? And for those of you who said no, if you're comfortable doing so, please share the reason for the opposition in the chat box. Okay, thank you. Okay, we can go to the next poll. Next slide. Okay, so this poll is regarding clients who have been granted U non-immigrant status. And when we say granted, we mean clients with a full 4-year U Visa grant, not clients who were put on the wait list or who got a bona fide determination. So for these clients who are in removal proceedings, my local OCC or Office of Chief Counsel will file or join a motion to terminate, oppose a motion to terminate, file a motion to oppose, other, or I've never had this situation. And for those of you who received an opposition, if you're comfortable doing so, please share in the chat box the location of your OCC as well as the date of the action. Okay, so that is good to hear that most of you have not had the situation of ICE opposing a motion to terminate. We have heard in the past of ICE either opposing these motions because the person they say that the person is still removable until they're an LPR. Our position is that individuals are no longer removable once they have received a U visa. If, for example, the basis of the removal proceedings was that the person was present without admission or parole. There is a BIA decision that's in your materials. It was an unpublished decision where they found that a U visa grant was an admission. And just so people know for the future, the proposition that an order of removal is canceled as a matter of law due to a U visa grant is not accurate with regard to orders of removal issued by an immigration judge. The regulation at 8 CFR 214.14 C5I holds that orders of removal issued by the secretary, so in this case by DHS, are canceled by operation of law when a U is granted. So that means, for example, expedited removal orders, but the statute doesn't allow for these IJ orders to be canceled by operation of law. But the regulation does allow people to file a motion to reopen and terminate one of these removal orders once the U visa has been granted. So moving on to the enforcement priorities, many of you may know that since the new administration came in January 2021, there have been various iterations of the enforcement priorities. The ones that I'm discussing today are the most current and updated priorities. They were released on September 30th of last year. The priorities are a threat to national security, a threat to public safety, which ICE defines as a current threat to public safety, typically because of serious criminal conduct, and a threat to border security. And this is actually defined relatively narrowly. It's apprehended, meaning stopped at the border or a port of entry while attempting to unlawfully enter the US, or apprehended in the US after unlawfully entering after November 1st, 2020. So this slide is just a summary of the enforcement priorities. The full priorities are in your materials, but what you will notice is that these priorities are relatively narrow. The threat to public safety generally requires that the person is a current threat to public safety, and the threat to border security are for relatively recent unauthorized entrance to the United States. What you will notice is that the fact that if someone is undocumented or has entered the US without permission in the past does not make them an enforcement priority on their own. Next slide, please. So ICE's prosecutorial discretion policy currently comes largely from two memos. The first is the 2011 victim witness memo from ICE, which is in your materials. This memo was never superseded. The second memo is the ICE victim-centered directive, which came out in August of last year. That is also in your materials. And these two memos form the basis of the prosecutorial discretion policy. Prosecutorial discretion is not a new concept. Basically, it holds that agencies that enforce laws can prioritize who to focus on when engaging in enforcement. But previously, during the previous administration, prosecutorial discretion was more de-emphasized. It is now coming back as something that ICE does. Under the 2011 victim witness memo, that memo generally holds that it is against ICE policy to initiate removal proceedings against a person who is known to be the immediate victim or witness of a crime, absent special or aggravating circumstances, and that it is appropriate to exercise prosecutorial discretion for victims of domestic violence, trafficking, and other serious crimes, absent these aggravating circumstances, which are involvement in serious criminal history, serious criminal activity, serious criminal history, national security concerns, threats to public safety, and being a human rights violator or engaging in immigration fraud. So you'll see that these aggravating circumstances are relatively narrow and many victims can benefit from this memo. The second significant piece of policy is the victim-centered directive that came out last August. Under this directive, absent exceptional circumstances, ICE will generally not take immigration enforcement action, which means, for example, stopping someone issuing a notice to appear in immigration court against people who have applied for and who are beneficiaries of immigration, victim-based immigration benefits, as well as victims and witnesses during a known criminal investigation or prosecution. So under the first prong, we're focusing on whether the person has a pending or approved application for victim-based immigration benefits. The second prong, it's irrelevant whether the person has a pending or approved application. Instead, we're looking at whether they're a victim or a witness in a known criminal investigation or prosecution. So first, who does ICE mean by applicants? They mean principals and derivatives. By principals, we mean the person who is the main person applying for the benefits. So for example, in a U visa case, the person who was the direct victim of the crime often will be the principal applicant. If they say have children or a spouse who they're applying with, those people would be derivatives. Both the principals and the derivatives are protected by the victim-centered directive. And by victim-based immigration benefits, ICE has stated that this includes U visa and VAWA relief. And by VAWA relief, they mean both VAWA self-petitions as well as battered spouse waivers for people who have a conditional 2-year green card and are seeking to remove the conditions on that green card. And I had mentioned that the policy is to generally not take enforcement action absent exceptional circumstances. So exceptional circumstances is actually a quite narrow concept under the memo. These exceptional circumstances include national security concerns, or if the person is an articulable risk of death, violence, or physical harm to any person. So the second one, for example, doesn't mean that just anybody who has a criminal history is considered to fall into an exceptional circumstance. There has to be that articulable risk of harm to another person. And under this policy, also absent exceptional circumstances, ICE will generally issue stays of removal to individuals who have pending or approved applications for victim-based benefits. So for example, if a U visa petitioner does not fall into these exceptional circumstances and they have an outstanding order of removal, under this policy, they should generally get a stay of removal, which would prevent them from being removed during that time when the stay is effective. And finally, for people who do not have a pending victim-based case, but are victims of a crime, the fact that they are a victim and may be eligible for benefits is a positive discretionary factor that ICE has to consider in deciding whether to take enforcement action. So even individuals who don't have a pending case, but are victims can benefit from this directive. And in terms of requesting prosecutorial discretion in removal proceedings and applying these two memos in your arguments for why a client should benefit, you would request it from the ICE Office of the Principal Legal Advisor, or OPLA, and their website contains email addresses and instructions for how to request prosecutorial discretion from different ICE offices. And it also lists factors that ICE will consider in determining whether to grant the discretion. Next slide, please. So matter of Cruz Valdez is a decision that came down last year from Attorney General Garland. This decision overruled matter of Castro-Tum, which many of you may have been familiar with. Castro-Tum was another AG decision that came down in 2018 that largely prohibited administrative closure in removal proceedings. With this new decision overruling Castro-Tum, it holds that unless a court of appeals, so a circuit court, has held otherwise, administrative closure can be granted in an immigration court case under the framework established in these two previous cases, Avedisian and WYU. And Cruz Valdez and Avedisian are in your materials. So now practitioners can once again request administrative closure in removal proceedings for clients who have pending U visas or VAWA self-petitions. And administrative closure does not terminate an immigration court case, but it removes it from the immigration judge's active docket. And it's a tool that's frequently used for individuals who have cases pending before an agency outside of the immigration court, for example, with USCIS. Next slide, please. Regarding the authority of immigration judges to terminate proceedings, There was a decision from the Attorney General in 2018, matter of SOG and FDB, and this case is also in your materials, stating that IJs have no inherent authority to terminate removal proceedings. Now, unlike matter of Castro-Tum, this decision has never been formally overruled, but its arguments and justification are very similar to matter of Castro-Tum, which has been overruled. And Chavez-Gonzalez v. Garland is a Fourth Circuit decision that came out last year that held that the plain language of the regulations authorizes immigration judges and the BIA to terminate removal proceedings. So for practitioners who are outside of the Fourth Circuit but are seeking to get removal proceedings terminated, for clients who, for example, have a pending U visa or VAWA self-petition, can make similar arguments to the court in Chavez-Gonzalez v. Garland to preserve the issue for appeal, either to the Board of Immigration Appeals or in federal court. But of course, a joint motion to dismiss that is joined by ICE counsel avoids this issue of IJ authority to terminate a removal proceeding. So this is only an issue if ICE counsel refuses to join the termination motion. Next slide, please. So what should we do now, given all of these new decisions and the new prosecutorial discretion policy from ICE? So we recommend that whenever possible, you request that ICE joins a motion to dismiss removal proceedings. And when you're doing so, you would be citing to long-standing discretion in the regulations for ICE to move for dismissal due to changed circumstances. And those regulations are 8 CFR 1239.2C, which states that after proceedings have started, the government can move for dismissal of proceedings under 8 CFR 239.2A. And one of the grounds in 239.2A is moving for dismissal when continuation is no longer in the best interest of the government. So when communicating with ICE counsel, you'd be making the argument that they have longstanding discretion to move for dismissal and that this is a circumstance where continuation would be no longer in the best interest of the government. In addition to citing the regulations, you would be citing the enforcement priorities we mentioned previously, especially if your client is not an enforcement priority, the ICE Victim Center Directive, the 2011 Victim Witness Memo, as well as specific positive equities in your client's case. And by positive equities, we mean, for example, a client having lived in the US for several years, a client having minor US citizen children for whom she's the primary caretaker, or a client having health problems that she cannot receive treatment for in the home country. You can also request that ICE joins in a motion for administrative closure, which, as we mentioned previously, can be done again with the holding in Cruz Valdez. And you can also request that ICE joins a motion for continuance of removal proceedings under Sanchez-Sosa. So Sanchez-Sosa is a case that sets out the framework for requesting a continuance of removal proceedings for U visa petitioners. And for both administrative closure and continuance motions, it's helpful to have DHS agree with you to file the motion, but it is possible to file opposed motions for administrative closure and continuance and let the immigration judge decide. Next slide, please. And I will now turn it over to Amy Chung, who will discuss the U visa bona fide determination policy.
Thanks, Kelly. I just want to reiterate that we are taking questions throughout. You don't need to hold any questions or comments till the end. And so please feel free to use the Q&A box or the chat box as we go, and we'll be monitoring them throughout today's session. So when it comes to the U visa bona fide determination policy, I'm sure many of you guys are already familiar with the policy. It was first announced back in June of last year, and I see a lot of familiar names in the participants box. So we do invite and welcome all of you to share your own feedback and comments about how the policy is working in the chat box as we go. So when we are talking about the U visa determination policy, we're going to be doing a little bit of polling and then also talking about how the policy is working, some unknowns that we are still facing, even, 8 months after the policy was rolled out. There's still some kinks to work out and some things that we don't know. So we're going to start off with some polling. The first one is, have you received a bona fide determination in a U visa case? And for those of you who are answering yes to this, please also share in the chat box when that case was filed. One of the things that we're going to be talking about is that we don't know how long these BFDs, and we'll be calling them BFDs today, are actually taking to process, because that information has not been made public. So one person says April 2017, that's one of the later ones that we've heard of, 2016. So it looks like of the folks who responded, about 45% of you have gotten a BFD, and then the others have not. So we can stop sharing that poll. And it looks like we are seeing a lot of BFDs from the second half of 2016, still getting some from 2015. We are hearing that as well, mid 2017. Great. So I think mid 2017 is probably around the latest that we've heard of so far. So you can tell that this is not a super fast process. I think we all had hopes that this was going to be faster than it was. And I think that it's still possible that it's going to pick up speed as it goes, but this is not a process that is going to take us from these 2015, 2016 backlogs up to current processing on U visas anytime soon. All right, the next poll, if we could bring that up. So the next poll is, have you received a notice that USCIS has declined to issue a bona fide determination in a U visa case? And we're being very specific about this terminology. USCIS says that they don't actually deny bona fide determinations, they only don't issue bona fide determinations, or they may decline to issue a bona fide determination, but they don't actually consider them denials. I'm just going to give it a few more seconds here. That looks like we are overwhelmingly looking at no. So we could go ahead and end the poll and share the results. So yeah, it looks like very few people have actually gotten a notice that USCIS has declined to issue a BFD. If those folks wouldn't mind sharing the rationale that USCIS provided in those notices in the chat box to share with us or to share with other folks, that would be really helpful to see. And I think this is pretty typical. We have seen a lot of BFD notices being issued successfully and BFD EADs being issued, but here and there we do see USCIS decline to issue these as well. We're going to talk a little bit about why that might be. Okay. So what is the policy? And I'm sure for most of you guys, this is going to be some review, but we are going to be touching on some of the common questions that we get on the BFD policy. And so the policy is that USCIS will review every single new and previously filed U visa petition for BFD eligibility, every single one. Okay. And the review for BFDs is supposed to be faster than how they were reviewing waitlist cases previously. The entire purpose of the BFD policy is that it's supposed to speed up these kinds of preliminary adjudications so that people can get EADs and deferred action while they're waiting for a full adjudication. And so the reason why BFD adjudications are supposed to be faster than the waitlist is because it's an abbreviated preliminary review. And so when they're doing the BFD review, they're only looking for a couple of main things. The main thing is that you've got a complete properly filed I-918. It includes the principal petitioner statement, which is required under the regulations, as well as a complete and timely filed 918B law enforcement certification. So those are the key components. You will notice here that the 192 is not part of the BFD determination. And so even if your client is inadmissible, they're not actually looking at whether or not a 192 was filed when deciding whether or not to issue a BFD. However, the BFD is discretionary, right? And so just because your client does have a complete and properly filed 918 statement and cert doesn't mean that they'll definitely get a BFD. USCIS is still going to be looking at whether the client shows any national security or public safety considerations. And you'll see in your materials, and we should have a copy of the USCIS policy manual for the BFD policy, and that lists out some of the specific types of criminal history that would be a particular concern for public safety. Keep in mind that this includes both convictions and arrests. right? And so there are some things, discretionary considerations, that could prevent somebody from getting a BFD, even if they meet the basic criteria. In addition, the client must be in the United States. This is because somebody who's not in the United States doesn't need deferred action and also can't use an EAD. And so that's why the person would have to be in the United States in order to get this. And we're talking primarily about principal petitioners here. In order for a derivative to get a BFD, the principal must get a BFD. And so they'll be, if everybody's application is pending at the same time, they'll look at the family together. But in order for derivatives to get a BFD, the principal must be issued a BFD. Now, if USCIS does not issue a BFD, then they're going to review the client's case for a waitlist adjudication. And so what you have here is that the BFD policy does not fully replace the waitlist adjudication. Both the waitlist and the BFD programs exist in tandem or in parallel with each other. And so first, everybody is reviewed for a BFD. If you don't get a BFD, then you will be reviewed for a wait list. And then if you get on the wait list, you get the same thing that you would have gotten under the BFD policy. You would get 4 years of deferred action plus 4 years of a renewable employment authorization document. Okay. And so that is one of the key points of confusion that we've gotten a lot of questions about. What is going on with the waitlist? Does it still exist? The answer is yes, the waitlist still exists for anybody who didn't get a BFD. And the waitlist adjudication is the same as it always was. For waitlist, they're looking at the entire application. They are looking at the 192. They're continuing to look at discretion, all of that kind of stuff. All right, so next slide. Let's talk a little bit more about these BFD. The first EAD is, there was a lot of confusion about that over the summer. We're going to be talking about that more, but the first one is free. It's going to be issued under category C14. So that's the category you're going to put on the I-765. If you're filing the 765, that's also the category that will appear on the EAD. And this is because the EAD is being issued pursuant to a grant of deferred action, and C14 is the category for deferred action. However, some and possibly many of your clients already have 765s pending. Many practitioners have been filing 765s under category A20 for derivatives or under C14 for principals or derivatives for the waitlist adjudication for many years. And a lot of people were doing this concurrently with the initial filings. You file your 918 and at the same time you file a 765. And all of those remain pending for people whose U visas haven't been adjudicated yet. And so as part of streamlining this EAD process, USCIS has said that they will automatically convert any 765s that are already pending for a U visa case to a BFD EAD under category C14. This means that if your client already has a 765 pending as part of the U visa application, they do not need to file another 765 just to get that initial BFD. And this deferred action and the EAD is going to be renewable in 4-year increments. This is true for both the BFD EAD as well as waitlist. But even though the first one is free, the renewals are not free. And so the client would have to pay the fee or file a fee waiver in the future. And at renewal, the USCIS is going to be looking at eligibility again. And so let's say your client was in the United States, they got their BFD EAD, and then they left the United States for some reason before the U visa was adjudicated, and now they are coming up on the end of their 4 years for the BFD EAD. They would not get another BFD EAD because they're outside the country now. And so they wouldn't be eligible for that at that point. Okay. And I see a question about 765s being rejected. We're going to be talking about that in just a moment. Okay. And next slide, please. How does this process actually work? One of the other main questions that we've been getting is whether or not practitioners need to ask USCIS to review their case for a BFD. The answer is no. USCIS is supposed to be automatically reviewing every single U visa case, both those that have already been pending as well as those that are being newly filed for EADs. There's nothing that practitioners need or should do in order to initiate that. What order are they going in? It's supposed to be first in, first out, starting from where the wait list left off when the BFD policy was announced back on June 14th, 2021. As we saw from people's responses in the chat box about the filing dates for the cases where they've gotten BFD EADs, they do range, right? And so we are continuing to hear about a smattering of cases from 2015 that are just getting notices, as well as cases from early to mid 2017 and throughout. But in theory, it's first in, first out. In practice, any case filed around that time frame could be in the running for a BFD EAD at some point, or a BFD determination sometimes. How long are these BFD adjudications actually taking? We do not know. There is a lot that we don't know about how these adjudications are actually going and how long they're taking. Part of this is because when they announced the BFD policy back in June 2021, they took down the case processing time that used to be on the USCIS.gov website. And what they said at the time was that they were going to put out the information January 1st, 2022, or whenever they have the adjudication processing time information, whichever is sooner. Obviously, it's well past January 1st, and we still don't have this information. And we don't know when we're going to get it. This is a question that we and other advocates have been raising to USCIS for some time. So we just don't have that information right now. As I said earlier, if you don't get a BFD, the case will go through to waitlist adjudication. When they notify you that you're not getting a BFD, they put the notification and an RFE in the same notice. And so you're going to get one letter that says, we are not going to issue a BFD. And also, this is the information that we're requesting and why. And so you will be notified when USCIS declines to issue a BFD. And then in terms of what happens after people get on the BFD, get a BFD or get on the wait list, these cases are still pending final adjudication, right? None of these cases have actually received the final U visa approval at this point. And so USCIS is still going to have to review all of those cases for the final adjudication when they come up, like when they come up in the line for that final adjudication. And they're all going to go in receipt date order. So it's not like the BFD cases go first, and it's also not like the waitlist cases go first. They all coexist together in parallel. And so whoever was filed first is going to be reviewed first, in theory, for the final adjudication. And of course, the case can still be RFE'd again or denied at the final adjudication, especially keep in mind for BFDs, they're doing a very preliminary review for those. And so there could be other 192 considerations, other discretionary considerations that are come up for the final adjudication that haven't been previously addressed. Okay, next slide, please. So in terms of what folks should be doing now, if you are filing a new U visa application, we do recommend including a 765 under category C14 with that application, whether it's for a principal or a derivative, and it is free, as we mentioned earlier. We've been hearing that these are going through pretty smoothly these days. There were a lot of problems over the summer into the fall with rejections of these 765s, but a lot of organizations, including the Immigrant Legal Resource Center, ILRC, did a lot of advocacy on this. And our understanding is that it has pretty much been resolved at this point, and that you should be able to file those without a fee and without a problem. If you are continuing to see problems with that, please let us know. That's something that we would definitely be interested in, and I think the ombudsman would be as well. If your 918 is already pending and a 765 is on file, there's no further action needed on your part. If a 918 is pending and there's no 765 on file, then you can decide whether you want to go ahead and file that 765 in anticipation of a BFD adjudication, or if you want to wait for that BFD letter. I think the advantage of filing that 765 under C14 now, as opposed to waiting for that letter, is that it can cut down on the delay for your client in receiving the EAD once the BFD is issued. We are hearing that for folks who wait until they get the letter to file a 765, they are taking at least several months to issue those EADs. And so if you've got a 765 on file now, it could cut down on the wait time for your client. And I know we got a couple of questions about the fees and the refunds for EADs. So let's talk about that on the next slide. Okay, so there were many issues and many rejections of 765 filed under C14 through the summer and the fall. It really looked like the USCIS mailroom didn't have its messaging consistent in terms of how they were supposed to process these applications. And as a result, we saw many 765s being rejected erroneously. Also, some people, they just wanted to get it on file. And so they were filing with a fee, and USCIS was taking those fees. And so USCIS has, as I said earlier, pretty much fixed this issue. And in trying to remedy the errors that were made over the summer and in the fall, they are supposed to be issuing refunds to anybody who paid a filing fee for a BFD EAD between June 14th and September 29th. And we've heard from a lot of practitioners that USCIS was issuing these refunds automatically. Practitioners didn't even have to ask for these refunds. What we recommend is that you take a look at your cases to see if you have any where the fees were paid between this time frame that fit these criteria, and to check whether or not USCIS has returned those fees. They're supposed to be returning all of those fees by March 22nd of this year at the latest. So if you don't get refunds that your clients are owed by that date, I would put a tickler in your calendar to follow up with USCIS at that point. Okay, and next slide, please. And we already talked about this. If you do have clients where the refunds are not issued by March 22nd, you can follow up with the USCIS hotline at that point. And they do have dedicated hotlines for these 765 refunds where you can contact them. And I also want to go through the questions because I did see some questions pop up as we were talking about BFDs. Okay, so one question, is there anything that we should be doing or be worried about if we have not received a BFD of a case filed before the end of 2016 and mid-2017? I probably wouldn't be worried about it at this point because, as we've seen, USCIS is all over the map in terms of filing dates for cases that are getting BFDs right now. So I don't think it's a particular cause for concern that they have lost your case or that something bad has happened. At the same time, I think it's always fine to follow up with USCIS about things like this where you're worried. And you can also see on the case processing website, even though they actually don't have the U visa processing times right now, they do have the processing times that were in effect at the time that they removed the information. So back in June 2021. And so if you have cases that are outside processing times based on that information, I think it's fine to go ahead and just reach out to the service center and see if they can give you a status update. I think chances are that they will not give you a super helpful response, but you can feel free to go ahead and contact them. Okay. And then one person said, I think this is in response to our question about folks who got a letter saying that they were not issuing a BFD. They got a notice that they were denying the BFD and sent an RFE to answer for the waitlist adjudication. And so that sounds like that sounds consistent with what they've said should be happening in these cases. The thing that I would watch out for if you do get notices saying that USCIS is declining to issue the BFD is they should give you a reason why. And if the reason that they're giving you does not fit with this very preliminary review that they're supposed to be doing for BFD EADs, that's something that we would want to know about, right? If they're looking beyond what they're supposed to be checking for BFD reviews, we would want to know that. And if there's a pattern, that's something that we would want to raise up with USCIS. Okay, let me see if there's anything else. All right, so great question. If a principal applicant included a payment for Form I-765 with their I-918, have you seen any success in requesting USCIS accept that payment for future renewal of their EAD? I think it's too early to say that because we're just starting with the BFD process now. And so I think that if a principal previously paid, they would have been paying for a C-14. And then the first BFD EAD is free. And so technically USCIS hasn't used that money yet. You would only be using that money for the renewal of the BFD EAD in 4 years. And so I think it's far too early to say that. If I had to speculate, just based on everything they've said about not issuing refunds for these previously paid fees for 765s, my guess would be that's going to be pretty unlikely, but we don't know actually for sure. The next question, are the Social Security numbers applied for with the 765s going well now? I'll put that out to all of you. So in your cases, when you have checked the box for a Social Security card to be issued concurrently with the EAD, how is that going? we've been hearing really mixed reviews about that, some significant delays in the issuances of Social Security cards. But if any folks have anything to report on that, you can do so in the chat box. Okay, and then we've got another question. So is it better not to list a C14 765 on a fee waiver request, even though we don't know if it will end up being a BFD EAD versus a waitlist adjudication based EAD, which may not be free? So that's a great question. And in the most recent USCIS listening session or presentation on BFDs, they said something very interesting about these waitlist adjudication EADs, which I took to mean that even if you file the C14 765 with your initial application and the case is ultimately approved for a waitlist adjudication instead of a BFD, that they're still not going to be requiring a fee at that point. I think their messaging on this could have been a little bit clearer. This is my interpretation of what they said. You can see a little bit more information about that in the practice advisory that we put out with ILRC that should be in your materials. Okay, and with respect to the SSN question, one person says that it's been going well, but they've also had problems in other cases, so it's mixed. So thank you guys for sharing that. Okay, and with that, I think we can go back to Kelly.
Thank you. So I'm going to talk about the Vangala settlement, which is regarding USCIS's previously in existence policy about rejecting visa applications due to blank spaces. Next slide, please. So we're going to start off with a poll. Have you received a notice from USCIS of a client's eligibility for benefits under the Vangala or no blank spaces settlement? Okay, go ahead and close the poll. Okay, so I'm happy to see that some people have been receiving these notices. For those of you who have not received notices, I would appreciate if you could put in the chat box if the client did receive a rejection due to blank spaces or if it's just a case where the Vangala settlement wouldn't apply. Okay, we can go to the next slide. So what happened is, many of you likely know, in late 2019, USCIS created this policy where they started rejecting U visa applications due to blank spaces. And this was foreclosing survivors from eligibility for victim-based immigration benefits. For example, if a survivor had applied for a U visa and they had a derivative child who was almost 21 at the time the U visa was submitted, and then that child subsequently turned 21 and the U visa was rejected because of blank spaces, that derivative child had aged out of eligibility. So this was causing pretty serious problems for survivors and their family members. Due to the issues that this policy was creating for survivors, a lawsuit was filed in November 2020, and that was the Vangala lawsuit. USCIS paused the blank space policy on December 22nd of 2020. And there was a settlement agreement in response to the lawsuit that was effective on July 20th of 2021. Next slide. Who is covered by this settlement agreement? Applicants, meaning both U visa principal petitioners and derivative family members, who submitted a Form I-918, which is the U visa principal petition, or Form I-918A, which is the family member petition, between December 30th, 2019 and December 22nd of 2020, and one or both of those forms were rejected because of the no blank spaces policy. And significantly, applicants who submitted forms that were rejected after December 22nd of 2020 may still benefit from this agreement. Next slide. What does USCIS have to do under this settlement? First, they're required to backdate the receipt date for rejected forms to the original date of receipt. And by rejected forms, forms that were rejected under the no blank spaces policy. So let's say that you submitted a U visa application for a client on October 5th of 2020. It was received by USCIS on October 7th. USCIS then sent you a rejection notice saying that the form was being rejected because, for example, your client left the middle name space blank and the client doesn't have a middle name. In that case, under this settlement, USCIS would have to backdate the date of receipt to October 7th of 2020 because that's the date that the original form was received. For age determinations, it's the age on the date that the form was first received by USCIS. So let's say in that case that I just mentioned, if there was a derivative who was 20 on October 7th of 2020 when the form was received, but subsequently turned 21 and the case was rejected due to blank spaces, under this settlement, the age of that derivative is determined on October 7th of 2020. So their eligibility as a derivative child would be restored under the settlement. And finally, for Form I-918Bs, which are law enforcement certifications that petitioners are required to submit with U visas, that's deemed valid as of the date of resubmission, as long as it was valid on the date it was originally received by USCIS and the certifier has not withdrawn that certification. So in the example I mentioned previously, let's say that the 918B was valid until December 1st of 2020. It's now 2022. As long as that 918B was valid at the time the U visa was received, which it was because the U visa was received in October and it didn't expire until December, as long as that 918B hasn't been rescinded, it would still be deemed valid at the time the practitioner refiles that U visa. Next slide, please. So you might be wondering, how do I know if my client is covered by this agreement? USCIS was supposed to have mailed notices by late October of 2021 to non-citizens who they identified as having their forms rejected under this policy. And the reason we asked the poll question was just to see if this has actually been happening, if USCIS has been issuing these notices like they said they would. So we recommend that you review all of your active U visa cases for rejections that appeared to have been for blank spaces. And if you identify a case that you believe was rejected for blank spaces, you can still request benefits under this settlement agreement, even if USCIS didn't send you that notice. Next slide, please. So what should we do if our clients are covered by this settlement agreement? First, very important to keep in mind is that you have to submit the request for settlement benefits to the appropriate USCIS service center by July 20th of this year. And that's because the submission of a request for benefits under the settlement has to be within 365 calendar days of the date that the settlement was effective. All resubmitted documents have to have attention Vangala in the address block, so USCIS knows that these documents are regarding the settlement. And regarding the form version of resubmitted documents, you can use either the version that was in effect at the time that you originally filed the U visa or the newest version of the form. Next slide, please. And regarding how you know which service center to file your request with, you could go to the USCIS website and then type in 918 and then click on where to file. And then that's where you would know which service center to send your Vangala request. What should you do if a client's forms are rejected? So that depends on whether you have subsequently refiled the client's U visa and had it receipted, or if you have not yet refiled. So if you have not yet refiled, you can resubmit it with supporting documents, and the supporting documents would be the Vangala settlement letter from USCIS if your client has received that, a rejection notice from USCIS, these are usually on blue paper, proof of receipt, so if you filed with a service that allows you to track receipt of the documents with USCIS, you would send that. And if you don't have any supporting documents available, you could resubmit with proof of delivery for the original filing. So you'll notice that often when USCIS returns documents to you, some of the documents will be stamped received and have a date on the stamp. So you could use that as proof of delivery, and or a sworn statement. Under the settlement, the sworn statement can be by the applicant themselves an attorney or accredited representative or another knowledgeable person, as long as it establishes that the form was rejected because of this policy. So for example, a sworn statement could say, I filed my U visa October 8th of 2020. The middle name box on the form I-918 was left blank. I do not have a middle name. My U visa was then rejected. That could establish that the person's U visa was rejected because of this no blank space policy. For those who have refiled their U visas, so for example, if they had got a rejection dated October 20th of 2020, and then they refiled and subsequently got a receipt notice dated, say, December 20th of 2020, that person can send a written submission to USCIS with the supporting documents that I just described and request a new receipt notice. And what USCIS should do in that case is send a new receipt notice for your client that lists the date of the form's original filing and receipt by USCIS. So if it was originally received October 20th of 2020, the new receipt should say under receipt date October 20th of 2020. And that would hopefully help if the client was farther back in the line, for example, for BFD processing, to get that earlier receipt date.
We do have a question. So it is, what if documents were resubmitted, but without the attention Vangala in the address box?
So I think in that case, I would follow up with USCIS. You could send an email to the hotline, which there's a handout in your materials with the hotline email addresses, and attaching your G28 and just confirming that the submission was designed to be for the Vangala settlement benefits, and just to make sure that USCIS realizes that's what the submission was for.
I don't think
someone's asking. Sorry, go ahead, Amy.
Go ahead.
I see someone's asking if there's anything that could be done when an I-918B has been certified and USCIS is requesting a new one and the certifier refuses to sign a new one because they already signed. In that case, I would talk to the certifier and just mention that USCIS, you can show them, even with the client's permission, a copy of USCIS's statement requesting a new certification to explain the reason why. And also assuming that the certifier signed because they have a policy of being victim-centered and wanting to facilitate cooperation with law enforcement authorities by letting people have access to U visas, you could let them know that the client may not be able to access this protection if they don't get the new certification.
Also, I don't know if this question was related to the Vangala settlement. If USCIS is requesting a new 918B because it expired because of the blank space rejection, you can remind USCIS that under the terms of the Vangala settlement, the 918B should be deemed valid as long as it was originally received by USCIS while, like, within the 6 months post signing. So if that's the issue here. We've got another question in the chat box. Do you know how long it's taking USCIS to reissue receipt notices after submitting a Vangala request?
I would open it up to the attendees to see if anyone's received a new receipt notice about how long did it take after you submitted the Vangala request.
Should we move on and just let folks answer, put that information into the chat box as we continue talking?
Sure. Next slide, please. Okay, so I'm going to turn it over to Amy Chung now to discuss the Medina Tovar Circuit Court case.
Thanks, Kelly. Okay, so Medina Tovar, again, I'm sure that many, if not all of you, have already heard of Medina Tovar, so we're just going to be hitting on a couple of the highlights for this case and some of the implications for your practice. If you go to the next slide, please. All right, so the issue and the reason why we had this case in the first place was because USCIS has had a regulation in effect for a very long time, saying that in order for a U visa principal to include qualifying family members as derivatives, that family relationship had to exist at the time that the principal's 918 was filed. And so this was primarily a concern for spouses, because obviously somebody could file a 918 and then during the many years that the 918 is pending, they might get married and they might want to include their spouse, but under that regulation that was in effect, they could not include that after acquired spouse. The remedy was a 929 for after acquired spouses, but that takes much longer. It's a longer process, and not everybody wants to wait. That is why this Medina Tovar case came about at all. And so it was this question about whether or not this USCIS regulation requiring the family relationship to exist at the time of filing the 918 is warranted under the language of the statute, of the UVisa statute. And this was a Ninth Circuit case, and the decision was issued in December 2020. And what the court found was that no, this regulation is not warranted. And what they were looking at was the statutory language in the UVisa statute at INA 101A15U, which talks about qualifying family members who are eligible for derivative U non-immigrant status. And so the idea is that because the statutory language talks about derivatives as accompanying or following to join, because the terms accompanying to or following to join have had a consistent usage in consular processing for many years, because we consider Congress to use commonly accepted terms and meanings when they're drafting statutes, the court found that the statutory language was clear that spouses do not actually need to have this qualifying relationship to the U1 at the time that the 918 is filed. Rather, the qualifying relationship must exist at the time that the 918 is adjudicated. And so what this means for UVisa cases, because these cases are pending so incredibly long, and you could have a lot of folks who are getting married in the meantime while they're waiting for their case to be adjudicated, those after acquired spouses now can potentially be eligible for 918As, and they don't have to wait for 929. And this case, as I said, is a Ninth Circuit case, and so it has been binding in the Ninth Circuit since the mandate was issued. But as a matter of policy, USCIS has also applied it nationwide. And so even though it's a Ninth Circuit case, by policy, which you can find in the USCIS policy manual, this does apply nationwide. And so the upshot for UVisa clients is that now, if you have, in particular, an after acquired spouse where they were married prior to the adjudication of the 918, that spouse can be eligible for a 918A. Okay, and so what this means is that family relationship must exist at the time that the 918 is adjudicated. It also does need to exist when that qualifying family member is actually admitted in unanimous. And so what that means is that if the family member is in the United States already, then they need to continue to maintain this qualifying family relationship when that 918A is granted. If they are outside the US and they're consular processing, they need to have that qualifying relationship when they are physically entering the United States on their visa. And even though the case is specifically about after acquired spouses, and even though I think most cases in which Medina Tovar is going to be relevant are going to be those involving after acquired spouses, you'll see in the policy manual that it's broader than that. It applies to after acquired qualifying family members. So it could apply to other individuals as well. But I do think that by and large, it's probably going to have the most impact on spouses. Okay, next slide, please. And so what should you do with Medina Tovar? I'm sure many of you guys have already done this, but if you haven't, I would review your pending cases to see if there are after acquired family members. This is part of maintaining contact with your clients throughout the pendency of their UVisa cases. So we're talking about very long stretches of time during which many things can happen to family relationships, right? And so maintaining that contact and following up with clients to make sure and see whether there are any after acquired family members who could benefit from this decision and policy. And if you do have clients who would benefit from it, then to go ahead and file those 918As for those individuals. If you have clients for whom a 918A was wrongly denied, I think the options differ a little bit if the decision was issued after Medina Tovar or before. And so if you got a denial after Medina Tovar came out, hopefully you already filed a 290B, because at this point, if it happened back in the beginning of 2021, it would be pretty untimely. But the idea is, if Medina Tovar had already come out, I think there's a fair chance that USCIS would have reconsidered that, because the policy is putting Medina Tovar into place for the entire country. Obviously, there are timeliness considerations there, but you can request sua sponte reconsideration. You can also file untimely motions. And we could talk more about the specific language at 8 CFR 103.5 and how it applies to motions to reconsider versus motions to reopen. Generally speaking, we've seen USCIS take untimely motions to reconsider as well, as long as you can show that the delay was reasonable and beyond the control of the applicant. So that's one consideration. If the denial was issued before Medina Tovar, I think that's going to be a more uphill battle, because USCIS has indicated that they see the pre-Medina Tovar denials as proper because this new law or this new case law wasn't in effect at that time. And so if you do have a situation like that and you want to explore your options, please reach out to us. We'll be happy to brainstorm. And of course, if the principal is still in non-immigrant status and the family member still has the qualifying relationship, you can file a new 918A. Or if the principal has adjusted and the derivative would be eligible for a 929, then that is another option as well. And that might actually be more straightforward in some situations. Okay. Were there any questions?
There were not, no.
Okay, great. All right, so with that, let's turn it over to Leah.
Yes, next slide, please. So we could not have a conversation without talking about the COVID pandemic. So next slide. Here is a chart about deadline extensions. So since spring of 2020, around the start of the pandemic, USCIS began issuing response deadline extensions due to COVID. And you saw these announcements were about extending flexibility for responding to agency requests. So on the left side of the chart here is if an RFE or notice of intent to deny or revoke is dated between March 1st of 2020 and March 26th of this year, a response will be accepted if it's received by USCIS 60 days past the due date that's on the notice. If it's a USCIS decision dated between November 1st, 2021 and March 6th or 26th of this year, 290B will be accepted if it's received within 90 days of the decision date. And I just want to note those 90 days include the 33 days. So it's not 90 days plus the 33, it's just 90 days. And so that example here, if a U visa denial is dated January 2nd of this year, your response has to be received, not mailed, received by April 2nd of this year to be considered timely. Next slide, please. So here we're having a fun little poll. Since the beginning of this pandemic, have you been able to schedule a biometrics appointment for a U visa or VAWA client who is living abroad? Yes, no, or not applicable. And please feel free to include details if you're comfortable doing so about your experiences in the chat box. And here is specific to biometrics appointments. Right. And that's about 60% of you haven't had to, but of the ones that did, the majority of you are saying you have not been able to schedule that appointment, but 16% of you say you have been. Please feel free to include details. I see some have been able to schedule until this year. Others are getting letters that the office is closed until further notice. Thank you. And please continue adding those details in the chat. Specifically too, if you can include where, like which consulate you were able to schedule that appointment. Someone only for El Salvador. Thank you. Schedule appointments in Guatemala and Mexico City. U derivative in El Salvador was finally able to schedule just last week. And in India as well. Okay, so seems to be a lot of different success, often with a bit of fighting to get that appointment. Okay, thank you. And please continue adding those details in the chat. Next slide, please. So scheduling biometrics. So the biometrics are the fingerprints, photograph, and signature of the applicant. UVis and VAWA petitioners outside the US generally are required to have their biometrics taken at a US embassy or consulate. As we know, though, the issue is that many embassies and consulates aren't taking fingerprints or scheduling these appointments due to COVID-19. So here are some practice pointers. Continue to check InfoPass appointments multiple times per day. This might also be a helpful thing to have your client refreshing that page on, especially because many have noted that appointments seem to open up around midnight. Might not be consistently, but a nice convenient time for everyone to be refreshing that page for an appointment. You can also check the embassy or consulate's website. Sometimes there's appointment scheduling information on their website to be able to get something maybe not quicker, but at least scheduled. Also, there's the option of emailing the visa section, whether immigrant or non-immigrant visa section at the embassy to inquire further about biometrics appointments. These email addresses can be found on the website of the US Embassy in your client's home country or country where they are currently residing. And it's important too to include any extenuating circumstances when emailing them, such as any age out that might be impending. So that would be flagged for them as well. That ideally highlights the urgency in getting an appointment scheduled. Next slide, please. As many know, though, despite these efforts, it can still be quite difficult to get that biometrics appointment scheduled. So what can you do then? First, you can email the service center hotline and ask for a new biometrics notice or notices and new deadlines. And importantly, to ask USCIS not to deny the case for abandonment. And so here, any documentation as well that appointments just aren't available can highlight that this request isn't due to avoiding the requirement of the biometrics, but that it's just not possible to get this appointment. And practitioners have reported success in getting multiple notices. And so please feel free to add those details and your own experiences in the chat as well. The issue with emailing the service center hotline that many have highlighted, though, is that responses can be delayed. Vermont Service Center, for example, I think says they're taking about 30 business days to respond. And so if you're not getting responses from the hotline, on the slide, there's a couple or a few options to take. So you can make a request with the USCIS Ombudsman, and that information is online. You can file that request online. You can also, where possible, use your congressional representatives or the client's congressional representatives to try to get more information or to try to get things moving along, if that's an option. And you can also contact ASISTA and we can provide technical assistance or see what we can do to help move something along as well. And I want to turn it to you as well. What has worked for you, especially where people have been able to push and get appointments scheduled, or what other challenges are you facing in getting biometrics scheduled for overseas clients?
As folks are typing, I think one thing that we've seen people do is also respond to the RFE in hard copy, as if you are filing an RFE response, and in your response provide documentation that the biometrics appointments are not available, and then ask them to reissue the RFE.
And can we go to the next slide? So we have a similar poll, but this is since COVID. Have you been able to schedule a consular interview appointment for a UVis or VAWA petitioner? And again, feel free to share your experiences in the chat. So for many of you, this hasn't been a situation you've come across, and a mixed bag of those of you who've been trying to schedule a consular interview appointment, whether you've been actually able to do. And so I'd love again to see your experiences where you've actually been able to get an appointment scheduled, and what challenges you've been seeing when you have not been able to get that appointment scheduled. And while you're writing the chat, next slide, please. Consular interviews. VAWA and U visa petitioners outside the US are required to consular process before entering the US. And as many of you, there's been increasing difficulty in getting these interview appointments due to COVID, where just appointments aren't available or there's very few available and different backlogs and just a lot, making it difficult for an appointment to get scheduled. So some options are looking at the embassy website for their own appointment scheduling information. And sometimes they will have information on expedited or emergency appointments. And if that is the case, if something needs to be expedited or is an emergency, it's important to flag that. So if there is an age out, an expiring U visa, a long parent-child separation, whatever factors that support the need for a quicker appointment, highlight that. Where documentation is there, document that as well. You can also contact the embassy's immigrant or non-immigrant visa section, again, being sure to flag any extenuating circumstances that might be applicable to your client's situation. Contacting your client's congressional representatives can also be an option. This might be more helpful when the primary petitioner is in the US, but a derivative is abroad, but could still be an option where necessary. And then we'd love to hear from you too. What has worked for you to get these appointments? One person said in Cairo, they were able to get an appointment, but asked acquaintances on the government side, and it was difficult, but was able to get an appointment. And they were only available certain days because many of them were teleworking. Okay. And that information of the Cairo hotline only be available certain days. Thank you for that information.
I wanted to highlight that someone had mentioned in the chat that USCIS is taking more than 6 months to send the receipts for cases. We have several cases that have taken 6 months, and we've come to think that they had not been received. So we have heard reports of long delays in getting receipts for U visa cases, particularly cases where the practitioner submitted a fee waiver request. So we would ask that you contact us here at ASISTA to flag those cases, and we could see if we can try to get the issue expedite, or we could get the case, do an intervention before USCIS for that case.
And I will highlight, with those delays, receipt notices eventually come, but some have reported 6 to 7 months wait time before getting those notices. Even if you were to email the hotline, there's no receipt notice to point to, so they'll just say there's no record of having the application. But we haven't yet heard where like the application is just lost or missing. It's just that it's the fee waiver requests have been so backlogged. And then somebody said, haven't been able to schedule biometrics for a T visa client in Honduras, and no response from the embassy.
Generally, when it comes to T visa issues and the embassy, we recommend contacting the International Organization for Migration, because they have a special human trafficking project that helps a lot with specifically consular processing. But my understanding is that they've been able to work some magic when it comes to biometrics as well. So I would recommend reaching out to IOM if you're dealing with T visa issues.
Thank you. And we'll go to the next slide, please. So COVID testing. So with one exception, everyone 2 or older that's entering the US by air, and this includes U visa and VAWA petitioners, have to present a negative COVID test that's taken within 1 calendar day of travel. This requirement is regardless of immigration or citizenship status, and also regardless of vaccination status. The limited exception is those showing proof of recovery from COVID within the past 90 days. But otherwise, everyone else needs to show this negative test. Please note this is by entering by air, so it does not apply. This testing requirement specifically does not apply if entering by a land border or a ferry terminal. So with this information, it's important to advise clients that are abroad of this requirement and to consider this when planning their departure date. And the websites, US embassy websites in the client's country can provide information about COVID testing that they should review prior to their travel. Next slide, please. So separate from testing requirements, there are vaccination requirements as well. So with limited exceptions, all non-immigrants, including U visa holders, if they're over 18 that are entering the US, and that's by air, land, or ferry, must be fully vaccinated against COVID. And fully vaccinated means it's 2 weeks after completing the 2-dose series or 2 weeks after the single dose of the J&J vaccine. So here too, it's important to encourage clients to get vaccinated if they're outside the US as soon as they can, and make sure their departure date gives time for that full vaccination. So it's not just that they've gotten the vaccine, but that it's also 2 weeks after that second dose or the one J&J dose. Again, the US Embassy website in your client's country can provide information about the COVID vaccine. I think something else about the exception. So the exception to the testing requirement is limited to those who can show proof of recovery from COVID within the past 90 days.
And then there is an individual who had asked which tests are accepted, which is a great question. There's a handout in your materials about vaccine and testing requirements. And under the testing portion of the handout, there's a hyperlink that you could click on that goes to a website that explains which are the types of tests that are accepted for entering the US.
Yeah. Next slide, please. For immigrants, the vaccination requirements. So the previous slide was about non-immigrants. This is about those applying for adjustment of status or an immigrant visa. So adjustment of status is applying for a lawful permanent residency within the US, and an immigrant visa is applying for that permanent residency from outside the US through consular processing. Generally, full vaccination against COVID is required for adjustment applicants as well as immigrant visa applicants. Part of the process is generally providing or going through a medical exam as part of the application for adjustment or an immigrant visa. Vaccinations generally are a part of that medical exam, and the COVID vaccine is now specifically a required vaccine and is part of that medical exam. We have a little asterisk there about U adjustment applicants. U adjustment of status is a discretionary benefit, and so arguably it doesn't require the medical exam because health-related grounds of inadmissibility are irrelevant to eligibility. However, USCIS doesn't quite agree in that they require the medical exam still, just as part of the adjustment process generally, but specifically they say they still review it as a form of a matter of discretion in the application. And so while there may be an argument that it's not necessary for you non-immigrants applying for adjustment, generally USCIS is going to require it anyway. And so U visa holders applying for adjustment should still be prepared to get this medical exam and the vaccine. So here we want to encourage clients to get vaccinated before the medical exams, and know that all vaccinations and the medical exam itself must be completed before the consular interview. So again, being mindful of timing and that requirement of 2 weeks after the last shot to be considered fully vaccinated prior to scheduling that consular interview. There's also a handout in the materials with links for finding vaccines. And for within the US, the vaccines.gov website helps to find vaccines and is also available in Spanish.
We had a question about vaccine, or if only Pfizer, Moderna, and J are recognized by the US. It's a great question for clients who are entering the United States from abroad. Vaccines that are listed for emergency use by the World Health Organization are also accepted, and hyperlinks for those vaccines are in the handout in your materials.
We've also got another question about whether the booster is required.
The booster is not a requirement at this time.
Thank you. Are there any other questions? And feel free to stick any other questions in the chat or in the Q&A box. And I think we have time for questions generally, so they don't have to be specific to COVID.
I think that brings us to the end of our slides. And so at this point, we have just general time for Q&A.
Yes.
All right, so one person is asking, do you have a link for the new law enforcement guidance? I'm going to be sticking a link in the chat. So the new law enforcement certification guidance just came out today, actually during this webinar. Obviously, we haven't had a chance to look at it, but the link is in the chat.
Someone's asking, they sent a U petition November to the Nebraska Service Center and still have not gotten a receipt number. Any suggestions on how we can get the receipt notice? We would recommend emailing the hotline with a copy of your G28, although as Leah said, it's unlikely that the response to that will be helpful. We also recommend that you contact the USCIS Ombudsman and do a case assistance request with them, as well as getting in contact with ASISTA about the issue.
And I will state too, Nebraska, I think, has been particularly delayed. Other service centers with receipt numbers or receipt notices, especially where a fee waiver or just no fee was necessary with the application. And so in addition to those steps Kelly mentioned, just know like the receipt notice could be coming. And if you do get a response from the hotline, it may be that they don't have a record of the application, or so they might say, we're backlogged, give us time. And then they might follow up to say they have no record of the application. I don't think that means that you have to refile. I just think the delays have been so significant that can and should still take those steps, but the receipt notice just may be still that significantly delayed.
A question about whether there's updated information on the CAM program and whether U visa derivatives are successfully entering. I actually don't have updated info on this. I believe USCIS is planning to hold an engagement session next week or the week after that on it. And so there may be more information coming at that point, but I don't think we do. I don't know, Kelly and Leah, if you have anything else on that.
No, I don't.
Someone's asking if we see cases where grounds of inadmissibility were waived at the U visa stage and then the applicants later denied at the adjustment stage for discretionary reasons, particularly with criminal issues. So we do see those denials. If that is occurring in your case, we would recommend that you contact us for technical assistance.
And if others can share their experiences too, on whether that's been coming up either as denials or even RFEs at the adjustment stage, what you've been seeing. But yes, as Kelly said, we have been seeing where USCIS is bringing up issues that were raised and waived at the U stage when the applicant's now applying for adjustment.
It's usually a particular problem where the client has additional negative discretionary factors that arose after the U visa was granted. But there are some cases where USCIS has denied the adjustment based exclusively on issues that came up prior to the visa approval. I see a question that the person submitted an AOS and USCIS spelled the applicant's name wrong in the receipt notice. They emailed the hotline regarding the incorrect spelling, but haven't heard back, and it's been 10 weeks. Is there anything else we'd recommend? Generally speaking, when it comes to the hotline, the first thing we want to make sure is that you're using the right hotline address. We know that we continue to see issues with people emailing at dhs.gov. Keep in mind that the correct domain name is at uscis.dhs.gov. So that's the first thing to check. The second thing to check is to make sure that you submitted a copy of your G28 with that email. If all of those things check out and you still haven't gotten a response, then you can either try again and see if it works better the second time, or you can reach out to us for technical assistance. And there are times that we can flag these kinds of non-responses to the hotlines, but only for Vermont and Nebraska. So if it's a different hotline, then that would be a different story.
So I wanted to just let everybody know, when you are submitting a request for technical assistance to assist, it's important that you schedule using the OVW, LAV, and STOP subgrantees calendar rather than the individual TA calendar. And we also wanted to flag that in your materials, there is a flyer that contains a link to register for an orientation webinar that will be happening on April 12th from 3 to 4:30 p.m. Eastern Time. And that will introduce grantees to ASISTA's benefits and how to register for appointments using our TA system. So again, that registration link is in the handout in your materials, and we hope to see you all there at the orientation. There aren't any additional questions. That is it for our webinar, but we can stay on for about 5 more minutes in case folks have additional questions.
For anybody who needs a certificate of attendance, please email us to request that, and we will be happy to get that to you. So the email address for getting the certificate of attendance is going to be questions@asistahelp.org, and that's also in the chat box.
So Lori was asking if there's information on our website about what public benefits are available to VAWA applicants with a prima facie determination by state. I do not believe there's anything on our website about that.
Yeah, so there's nothing on our website about it, but there is on the New App website.
New App, right.
So that is in the chat box.
Okay, that is it for our webinar, and thank you again to all of you who attended, and we hope to see you again on April 12th for our orientation.
Thanks, everyone.
Thank you.